Hello viewers, this is me. I am going to share with you Houston Maritime Attorney. So, Blank Rome in launch its Houston prison when it complete with arms. Scott and Brickley in June 2011, adding corporate at litigation attorneys and with significant energy industry experience. The firm continued its growth in Houston with the addition of the maritime lawyers of Bell, Rinker and Lithuania in August 2013. Strand happening, its maritime practice in a key market of maritime law with the addition of the intellectual property attorneys from Wrong, Cabillo, Lurs, Rutherford and Buscolari LLP in June 2015, which significantly bolstered the firm's national IP practice and capabilities. Blank Rome has built a diversity presence in Houston, boasting great legal talent in a robust market for our clients. Our Texas-based team work with our Blank Rome litigation attorneys in our office access the United States as well as known office in Shanghai who handle a wide variety of civil, criminal and administrative matters in state and federal courts. At both the trial and appeal level, our attorneys represent very corporate, government and individual clients on diverse litigation matters including securities, commercial, intellectual property, taxes, tort and product liability, maritime employment, appellate and white-collar defense and investigations. Our Houston office also offers excessive experience and compelling opportunities to expand the firm's growing Asia practice. Maritime law attorney made Maida Law Firm. Houston Maritime Law Attorneys maritime occupation are particularly hazardous. While your employer has the obligations to protect you and to minimize the risk of injury, working on vessel and rig is inherently physical work and foreseeable injuries happen especially when employers are lax in their producer, maintenance and oversight. Employers often fail to protect their dedicated worker. We handle Jones Act, Longshore Act and rig workers claim. We try cases to state, federal and administrative courts across the nations. Accident and injuries can end your career as a seaman, longshoreman and oil rig worker. The physical demands of working at sea make injuries to hands, arms, legs or back very possible and possibly catastrophic. Your livelihood and the support your family are at stake if you have been injured as a seaman, longshoreman or oilfield worker. You need to fight for the compensation you deserve. Your employer is unlikely to compensate you fully. You expect undeserved representations to fight for your rights and get you what you need for a full recovery. We have maritime attorneys who can help fight for your rights. Admiralty and maritime law definition. The admiralty and maritime practice involve all aspects of legal work relating to maritime activities. This includes litigations, commercial transactions and non-litigation counseling as well as regular work before federal and state agencies. Firms with litigation caseloads generally represent clients in matters involving compensation, maritime, commercial disputes, and insurance covers relating to inland marine vessel, ocean-going vessel, passenger vessel, drill rigs, and other offshore equipment. Frequently, these firms also handle marine-related issues involving mass disaster. Major pollution includes toxic torts class action. Due to nature of when and where clients needs arrest, authorities in this practice frequently are on call 24 hours and travel to distant and something remote locations. In the areas of commercial and in counseling, maritime authorities handle issues relating to vessel sales, shipyard contracts, maritime insurance counseling, and evaluation contract and charter drafting, negotiation and maritime finance advice. In the context of regulatory arena, authorities typically appear before the United States Coast Guard, Federal Maritime Commission, United States Department of Labor, and the National Transportation Safety Board. Feature of Admiralty Law, Maritime Law set forth many four of the basic legal tenets associated with the sea and seamen, including the rights of our recover resource claim in marine silver award for recovering property loss of sea. This right for creditors and seamen who are one was to have maritime lien against basis security interest insured to pay duty of ship owners, provide responsible care to passenger. The ship owner just as if the injury had occurred on land. The benefit of maintenance and cure, which requires ship owners to care injured crew, maintenance solicitation. Ship owners provide seamen with basic ship owners to provide free medical care, even if that care is long-term payment until as a seaman reaches the state of maximum medical care as medically possible of the condition the seaman was in before an injury. In maritime law cases in the USK, originally given to the federal court, however, today most admiralty cases can be both state federal courts. To suitors cases, state court the to any matter any maritime property, those cases may be only tried in federal court. In state court provide admiralty case, the case is required admiralty maritime law, that is state law. How does maritime law provide to hard worker? Without maritime law injury, seamen would be left on their own to contract the suffering they sustain while working. Anytime a ship employer becomes injured, is sick. This remember is maintenance at core, meaning until seaman fully recover, employer